Good afternoon, everyone. My name is David Patariu, and I'd like to welcome you to the Mitigating Unauthorized Scraping Alliance webinar. And we are so pleased today to have Scott Giordano with us. He is an expert in cybersecurity and privacy law. He lectures all over the country, teaching privacy lawyers and cybersecurity lawyers how to do their jobs. And it is such a pleasure to have him here today. Scott, please introduce yourself to our audience.
Wonderful. Thank you for having me on, Dave. By the way, I appreciate the invite. Scott Giordano. I'm a career cybersecurity, privacy, and now AI attorney. I've been worked in the private sector, typically in-house for the vast majority of my career. I've just spent, especially the last 6 months, immersed in all things AI and have, as you mentioned, spoken all over on the new phenomenon that AI is, and it's great to see all the different changes to technology and to the law, and it's a great place to be right now.
So we're going to start our deck right now, and today we're going to be talking about Scraping 101, navigating AI, privacy, and legal minefields amid unauthorized scraping. And I would like for you, Scott, do you have any intro thoughts as we begin here about scraping in general?
It's such an interesting phenomenon because I mean, scraping's been going on since the internet. I mean, you think about how many years we were into this now, and this idea of scraping data just goes way back. It's in the past years, as our audience knows, it's taken on several twists with the High Q case and with CFAA and all of that, and now, of course, with AI, that changes the whole dynamic because now scraping is not just a nuisance, but it's a potential privacy threat.
That's right. So let me move to our first slide here, where you get to just share a little bit more about yourself, Scott. And I think it's important for the audience to appreciate the your background and everything you bring to this conversation.
Oh, thank you. I appreciate that. My subspecialty is multinational and cross-border, all aspects of that, cybersecurity, privacy, AI. Spent a fair amount of time with the IAPP folks on one of their boards. Also spent a lot of time in the e-discovery space. So those of you that are involved in e-discovery or have been, I spent about a decade of my career involved in that. I taught the first law school course on e-discovery at Loyola Law School in Los Angeles. And recently, I just wrapped up being a general counsel at a tech firm. So very happy to be involved in all things AI now. It's very exciting.
And Scott, why this webinar? Why is this such an important topic for your fellow GCs and CISOs to understand?
I think it's important because, and I think I alluded to this earlier, is that scraping's been around for a while, but AI has just turned it on its head. And I mean, I think probably everyone on this presentation is familiar with Clearview AI and all the drama associated with that. And I don't want to spoil the discussion. We'll talk about that. But that really precipitated all kinds of discussions about AI before AI was even generative, when it was just quote unquote regular AI. And now this is a problem we can't escape. It's facing us everywhere. And if AI turns into a privacy free-for-all, then there's essentially no ability to protect our privacy.
And Scott, as a GC, I guess, why do you care? Why, when you were advising your company and the companies that you currently advise now, that you have a law firm and that you're kind of working with different clients, why should your clients care? Why should people watching us today care about this important issue?
They should care because there's nothing cut and dried about this. For example, the whole high Q case about whether it was a CFAA violation or whether it's simply a contractual issue, which is ultimately I think what it turned into, or unfair competition. I mean, there's so much nuance here that you can't ignore it. There's way too much. And then, of course, we have the whole issue of how is the EU AI Act going to take a look at this, and how are you going to have to change things to comply with that? There's a lot of work to be done here, and we're just getting off the ground.
And I think something else we had talked about before this began was certain regulators might be referring to unauthorized scraping as a breach, but could you tie that together with the new SEC cybersecurity regulations and why that might be problematic or concerning for our audience?
Yeah, in a nutshell, and again, I think we'll dig into this in great depth, but in a nutshell, I think characterizing scraping as a breach, I think it really doesn't advance the interests of data protection authorities because a breach when it happens, it takes on a life of its own in the sense that certain things have to be done. For example, as a GC, I had to, in all of my agreements, address the whole issue if there is a likely or confirmed breach, who had to be notified, when they had to be notified, how evidence had to be preserved, the whole issue of waiving privilege vis-a-vis your chain members, your supply chain members, all of that comes into play. And it creates sometimes some very contentious negotiations. And so this is something that has to be addressed now. It's not something that you can really wait until something bad happens.
And Scott, if our audience leaves with nothing else, what should they take away from this presentation we're about to do?
Really, artificial intelligence, and forgive me if I'm sounding a bit cynical here, but it really amplifies the ability of bad people to do bad things. And I don't think there's an appreciation of that quite yet. I mean, we've seen some things in the news about celebrities being victimized by AI, but this is going to get a lot worse before it gets better. And so it's important for us as we leave this presentation today to understand that we have to be able to dig into this, understand the nuances of scraping, and whether calling it a breach really is helping anyone or it's just obscuring a larger issue, which is what's being done with the personal data that's being scraped as opposed to the mechanism itself.
That's great. So let's get into it and talk about what is scraping and help our audience understand what is this issue that we're actually talking about. Some of you may not be familiar with scraping. Some of you may never even heard about this term before, or be confused and think it's, scraping old computer screens that are COBOL programs or something, which is really not what we're talking about here. We're talking about online web scraping. So let's kind of jump into the OWASP definition. And Scott, if you would take us through this and kind of talk about what OWASP is and why their definition is helpful for the people watching us today.
I mean, OWASP is the open web application security project. So imagine, I mean, I'm sure everyone in the audience is familiar with things like vulnerability scans, for example. Imagine that an entire nonprofit organization, a community organization, is developed just to address things with respect to authentication and also to addressing the security of the interface between the web and everything else. I mean, that's the best way to describe it. I know I'm not doing these guys justice because the work they've done is so prolific, but it's this idea of the web versus the rest of the world and how the rest of the world interacts with the web. I mean and so whenever you hear stories about we're doing pen testing, we're doing any kind of vulnerability scanning, anything in that interface, that's what we talk about OWASP. And again, I'm underselling them. They do tremendous amount of work. Hopefully we can talk more about that.
And we have a description of what OWASP kind of characterizes scraping as generally. And if could you walk us through that a little bit and kind of talk about, it seems like it's, collecting accessible data, but, how can a practitioner use this kind of a definition?
I mean, I think the best way to describe it is you think about a robot or a bot or whatever you want to call it that will crawl the internet as it's been crawling like forever and essentially copying information. And that's basically what it is. It's harvesting or copying information. And you remember, and forgive me if I'm dating myself here, but we all remember back in the early days of the internet where we had bots all over the place, or spiders, or whatever you want to call them, crawling the web, indexing things, or they were capturing information and then sending it back somewhere else. I mean, that hasn't changed. That's been, and we used to call that screen scraping back in the day. Now I guess it's just scraping, but it's this idea of just collecting information. And one of the challenges is having someone who's a quote unquote holds an account on your media, say that it's a LinkedIn account, creates a false account, for example, and then uses tools to go and grab information that is against the terms of service. I mean, that's the kind of issue we have now versus regular bots just crawling the internet and just grabbing everything they can get their hands on.
And Scott, I noticed you had I think you have a patent for search technology. And can you help us understand if I'm thinking about search like an indexing to facilitate online search versus scraping? The way I think about it is, okay, well, this is helping end users find a resource
Mm-hmm,
online, and the bot is crawling over things and
mm-hmm,
processing and saying, okay, this is the best place to find
mm-hmm,
videos about
mm-hmm,
cats and laser pointers or something like
mm-hmm.
that.
Yeah.
Whereas the scraping is actually taking the information and doing something else with it altogether, downloading it, grabbing it, collecting it, and then doing something else. It's not really helping end users find a resource on the internet. Do I have that right, or?
Yeah, yeah, absolutely. And I apologize if I conflate it. I didn't mean to conflate the two. I think I was trying to articulate what was going on in the early days of the internet. Yeah, you have indexes. You have tools that will index the internet so that you can run searches instantaneously and get results. You have also tools that were just grabbing information. And they are a new, I agree they're a nuisance, but they're just a part of the internet and they've been around and they are a daily event, if you will, on the internet.
So now let's look at some of the other, I think this slide kind of covers some other groups and how they define or how they treat scraping. So we have, I guess we have an acronym soup here. And
Hmm.
I guess KPIC category, that's the common attack pattern enumeration and classification categories. And it seems like they're treating scraping as an abusive functionality. Does that make sense to you, Scott? Or is this
Yeah, I mean,
question?
arguably, and in fact, in the past, when it became a problem, it was when there was litigation about it early on in the internet. This was really treated as a trespass to chattels in the sense that you're interfering with someone else's website because so many bots were crawling all over websites, they were slowing down the functionality. So it's an abuse of functionality. I mean, it's the best way to articulate it. However you do.
And the CWE or the that's another one, common
Mhm,
weakness enumeration, improper
mhm,
control or
mhm,
interaction frequency. That's a mouthful. WASIC is again an abusive
mhm,
functionality, and then OWASP
mhm,
seems to like so it's an abusive functionality or an abuse of the site or the property. I
mhm.
guess is a takeaway from these different definitions. I mean, is that kind of the way you think about it as a cybersecurity
Yeah,
professional?
I mean, you think about the internet is internet is based on trust in the sense, at least it was originally, in the sense that we're a community, everything's based on trust. You're trusting that other people aren't going to abuse the privilege of being able to search for everything instantaneously. And by using these tools to go and constantly grab sites and scrape information from sites, it destroys that trust. It destroys that functionality.
And just to take a step away, the way I kind of explain this to my friends who like, ask or see these webinars on YouTube and stuff is when I think about scraping, to your point, it's more like an abuse. Somebody you invite to your wedding and then they're standing there and they're eating all the wedding cake. And they're allowed to be there, they're allowed to be at the wedding, but they're
Mhm,
doing something that's a total abuse of the privilege of being a wedding guest or being invited to an event versus, I guess, an intrusion that will be more like somebody crashing the wedding that wasn't
mhm.
invited at all. Is that a good way to think about this, or am I kind of?
It is. No, you're spot on. One is an abuse of the privilege of being part of that community, and another one is simply being boorish. And unfortunately, I think that a lot of this activity is boorish.
That's right. Okay, so now just to talk through, just to get a little more into the weeds. So we have this one abusive functionality, and it seems to say it uses the website's features and functionality to attack itself or others, and abuse of the application's intended functions. So that kind of aligns with what we were just talking about. And then the KPEC categories, the same idea that it seems to take it abuses the site or the functionality of the site to do something else that was not originally intended by the application. And I guess that's how we understand what's going on with scraping is that you're putting information out there, but it's not intended for a third party to just take it and do something else with it. Is that kind of in line with how you or your client?
Yeah, well, let's think about the extreme situation. This would be a DDoS attack. A DDoS attack is essentially an abuse of the technology of TCP/IP that the internet is based on, and it's done to harm others. Okay, that's a DDoS attack. That's the extreme end. If you have enough of this abuse, at some point it crosses into the realm of a DDoS because you're destroying the functionality of the site, which is to serve the community as a whole, and they're doing so without any benefit to anyone else except themselves.
That's right. Now, I just want to turn to now Musa. We have defined or we talk about scraping in our practices guide. And we talk about, unauthorized data scraping is the automated collection of data at scale that violates a platform's terms of service. And you mentioned trespass to chattels, and maybe we could talk a little bit more about
Mhm.
that. and what that actually is. Because, a site may have, and so just to terms of service versus privacy policy, and if you would be able to kind of walk our audience through the difference between the two, because a lot of times you see even privacy professionals make the mistake between, terms of service and privacy policy, and then how unauthorized web scraping would be a violation of the terms of use or terms of service.
Well, I mean, first up, a privacy policy, probably the worst pair of words that we've had in the last decade or so. Really, when we see privacy policy, we really mean privacy statement,
Mhm.
and essentially, it's a statement about what a company does with personal data. Quite literally, it's not a policy because a policy is something that if you violate it, you can be punished. So clearly, that's not the case. You're essentially creating a statement telling the public, "Hey, this is what we do with personal data." So you're creating transparency, a la GDPR or any other local laws we have in the US. But the idea is that is simply a statement. That's it. It's not a contract. Repeat, not a contract. This is something that drives me nuts when I go onto some of these websites where they say, this privacy policy is a contract. It's like, no, you do not want to do that. You do not want to get yourself into court over something unnecessarily. Don't use that to create a contract. It's terrible. So that's a complete separate issue from terms of service, which is this is what you can and can't do on the website, quite literally. And if you don't do things the way we ask you to do it, either stay off the website or you expose yourself to litigation. That's it.
So yeah, I agree. I mean, the way I think the Europeans, when they kind of talk about this, or in the GDPR, they talk about a privacy notice. And it's to your point, it's more like, hey, this is what we're going to be doing with your data. This is how we treat it. And there are some obligations under the various regulations of how to lay out, explain that to end users. And I think the important thing is that if you don't allow scraping and you're explicit about that in your terms of use or terms of service, it is unauthorized and it is a violation. And so I think a lot of companies need to start reviewing their terms of service or terms of use and seeing if they have that kind of language in there, because otherwise they're kind of left out in the open. I mean, have you seen a lot more companies trying to add that language, or in your practice, Scott, or are people still in the dark about this issue?
I have seen people add this, or I say companies add this. I mean, typically, I think counsel, at least in the privacy community, is pretty on board with this kind of thing. And so that whenever I do a routine review of someone's privacy statement and their TOU, that I'm going to look for those things. And if nothing else, make sure that it's very explicit in the terms of service, the TOU, that hey, you can't do this. And if you do it, it violates the TOU and you expose yourself to litigation, and make sure that it's very explicit that you cannot scrape the site, full stop. Now, is that going to necessarily stop everything? No, because the scrapers may be overseas. There may be all kinds of things that prevent you from doing that.
So now we have the ICO, which is the regulator for the
Hmm.
United Kingdom, and
Hmm.
the Information Commissioner's Office, and they have a definition for what is scraping that's a little bit different or just a little more elaborate. And just to read it for people who are maybe not looking at the screen right now, web scraping involves the use of automated software to crawl web pages, gather, copy, and extract information from those pages, and store the information, for example, in a database for further use. And the information can be anything on a website: images, videos, text, contact details, etc. So that definition is a little more color. And I think it kind of touches back to your idea, Scott, that you kind of related earlier about crawling web pages, or scraping to gather this kind of information. I think,
Hmm.
I mean, what do you think of this definition? It's pretty solid, right? I mean,
I like it. I like it a lot because I think it essentially encapsulates everything that we understand about what scraping is.
and now, so we're gonna borrow the ICO's great image that they put together to talk about. I guess you mentioned at the very beginning of this that data scraping or online web scraping is currently being used to build generative AI models. And I don't know, Scott, at a high level, if you want to kind of talk through that, and then we can pivot to talking about the images that are on here, the kind of the ICO's description of it.
Sure, there's really two two big pictures models, if you will, for AI. When I was working in eDiscovery, we worked with AI, specifically non-generative AI, what we would call deterministic AI now, where you still train on giant data sets of documents that are relevant for a specific matter, and a set of documents that are not relevant for a specific matter. And so you train the model so that when you do then apply the model to a much larger, it could be terabytes of data, then in principle, it's going to be deterministic and say, yes, this set of documents is relevant and responsive to the request, and therefore this is part of the larger corpus of discovery. So that is deterministic. Then imagine that's writ large. Maybe it's hundreds or thousands of times larger than that, and you're grabbing everything you can find. You're grabbing things from Reddit. You're grabbing things just from the internet in general, from forums, from different discussion forums. You're getting books that have gone into the public domain or perhaps not in the public domain. You've just grabbed everything you can possibly get your hands on and took that and basically crunched that into a database. Essentially, it's a vector database. You've turned everything into ones and zeros effectively. And then from there, then you have an algorithm that will go and ingest that and review it and understand what it is, make sense of it, if you will, at least from a machine's point of view. And then it essentially digests that. And that's something then that can be queryable, if you will, on a human or by a human. That's in essence what generative AI is. And because you have to have so much data to make it simulate what a human would say, that it's quite prolific in terms of just having to scrape or to ingest as much data as it can possibly get.
And you've seen me do this before, Scott, but
Mm-hmm.
I think about generative AI or the training process as you have
Mm-hmm.
the training set or the training data here.
Mm-hmm.
And even before that, all the way over to my left-hand side,
Mm-hmm.
you would have the data that was scraped or collected, that
Mm-hmm.
large corpus that then
Mm-hmm.
somebody kind of goes through and says, okay, I want this in my
Mm-hmm.
training set.
Mm-hmm.
Then you have the model. And then
Mm-hmm.
on this side, you have the
Mm-hmm.
model output or the front end of the
Mm-hmm.
model.
Mm-hmm.
And is that how you think about it, in the sense of where does this scrape data sit in this system of, model, training set, front end of the model, that everybody, the prompt, or where people enter their queries to ask these systems questions? Is that one way to think about it, or like kind of where
Well,
does that sit, that scrape data?
I mean, it depends. Presumably, if you're scraping data, you're not going to label it all. So it's not going to be a supervised training that you're going to do. You're going to ask the model or the tool that does the scraping, or some logic, to go and essentially learn and assess what that information is on its own. So essentially, that's unsupervised learning, if you will. And then from there, presumably, you can then, if you want to, start sampling it and labeling the information and retraining it. So there's different ways that you can do this to be able to create some sense of what all this information means. So you can have supervised versus unsupervised. You can have semi-supervised. You can have it reinforced, where, for example, cars, when they're automated cars, when they're learning how to drive without a driver, they get reinforcement training. So there's different ways of doing this. Ultimately, that's going to be digested and it's going to wind up into a database. And then the algorithm is going to have a very good idea about how to make sense of it and how to add weights to certain things. And it's an iterative process. It's very computationally expensive, which is why companies don't want to constantly retrain their models. They want to train it once and then do update training. So to the extent that we're talking about is consistent with that, I'm definitely in agreement.
And just so people understand, I think you were kind of touching on this before. There's a difference between an AI classifier and generative AI. And that my understanding is generative AI makes something new. So you might train an AI on, so say, a folder full of bird pictures or cat
Hmm.
pictures. And then you're going to ask after it's trained. So you have your, maybe scrape data of all these cat pictures from all of the internet. Then you train
Hmm.
the model. And then at the front end, you're going to say, model, generate a new cat picture. That's why it's
Hmm.
generative AI.
Hmm.
That's different than an AI classifier, which is kind of something you mentioned, which is if I show a model a bunch of cat pictures and then I say, is this a cat or a dog?
Hmm.
It's going to say, okay, that looks more like a cat. This looks more like a dog. And that's a different kind. It's not making something new. It's helping somebody determine or figure out what a new piece of information is based on what it's been trained on.
Exactly. So this is the difference between deterministic AI. Again, if you're in the e-discovery world, you're familiar with deterministic AI, saying yes, responsive, no, non-responsive, versus stochastic, meaning that it's not going to necessarily generate the same picture of a cat every time. You could ask it 10 different times, you're going to get 10 different cats, presumably. So, and that's another thing that I don't think people appreciate is that you never know what's going to come out of a deterministic, I'm sorry, a stochastic like ChatGPT. You're never sure what's going to come out when you ask it a question because it literally can give you the different answer every time.
That's so helpful for our audience. Well, let me share the screen again here, and I'm going to try to do this the right way. There we go. Okay. And so now, like getting back to what the ICO included in their consultation, and they were seeking information about what people thought about um, legal bases and artificial intelligence and generative AI work. This image that they have here, it shows the data
Mm-hmm.
collection piece, and I guess that's where the scraping would go on.
Mm-hmm.
And
Yep.
then to your point, what Scott, you were kind of describing, there's the pre-processing, deciding what would be in a training set that then is used to train the model. That's in that second row. And finally, you have the fine-tuning of the model, which I guess they might use scrape data, they might use other data to kind of make some adjustments to the model output. And is that pretty accurate or
Yeah.
roughly
Yeah.
with
This is exactly how it works. You collect the data, you pre-process it. And there's all kinds of things you can do to pre-process it. It's going to vary. It's going to go into the model. The algorithm is going to assign weights to certain things. And if you don't get the answer that you were expecting, you're going to ask it to go back and try again. And so there is going to be a lot of fine tuning of the data set until you get what you're expecting to get. Again, even though with generative AI, it's going to be different every time. If you ask it to generate a cat and it gives you a snake, then clearly there more fine tuning needs to be done. And then finally, when everyone's happy with more or less where the state of the AI is, then yes, you could offer it to the public and see what kind of trouble they can get into with it.
Now, there seems to be, now moving from this slide, there seems to be a lot of issues today with unauthorized web scraping. And I can, let me see here. And there's been books about it and kind of a lot of coverage in the press. Scott, could you walk us through like what you've seen and what you think would be important for our
Sure.
audience to know?
I mean, the archetype for this whole discussion, I think, is Clearview AI, and the book here, Your Face Belongs to Us, really chronicles the whole story about Clearview. And in essence, what they did is they they scraped, okay, faces. I believe 5 or 6 billion faces from just from Google, from LinkedIn, from Facebook, from just anything that's publicly available. Applied an algorithm to it, and there was a lot of trial and error till they got it right. But then once they more or less got it right, they made it available to law enforcement and to corporations, and it became a scandal because at least on the EU side of things, there was no legal basis for doing this. I mean, and they were making this available to way too many people, i.e., governments overseas. It wasn't just limited to democratic institutions; it was really all and sundry, and that did not go over well with the EU authorities. And so they've to date have been fined about 75 million euro or so, and there's been plenty of litigation here on the U.S. side as well.
And there have even been books written about it, right? I have this image in your slide deck, Kashmir Hill, New York Times bestselling author, Your Face Belongs to Us. And I think the book kind of covers the whole Clearview AI
Yeah,
issue and the data scraping. Definitely something that our audience might be interested in reading
yeah.
if you want to learn more about online web scraping. So now kind of moving to
Hmm.
our friends at OWASP again.
Hmm.
And why is and highlighted in red here in the deck
Hmm.
is training data poisoning. And why has that now become an issue? And how is that relevant to scraping?
It's an issue because for a variety of reasons, but one is just the integrity of the data that's coming out of your LLM. Okay, if the training data is subject to being tampered with or manipulated, I'm less concerned with someone going in and deleting it. I'm much more concerned with someone putting in fake data in there to create a desired output. I mean, you could create essentially a libel or a defamation machine, if you will, just by putting in certain data and having it the LLM train on that. And then if someone does a search for you or someone you know, potentially come up with all kinds of awful things. So the fact that it's number 3 on the list, it probably should be a little higher because it is an existential threat to all of us.
So I guess that's another issue is that some people realizing that entities are scraping data are now
Hmm.
poisoning that data. And if you're not careful, that poisoned data may wind up in your training set and um, cause your model to not perform as expected or to have unusual outputs. I guess that's the risk there, right, Scott?
Oh, there's all kinds of risks. There's risks that someone deliberately is poisoning the data that's going to get scraped. There's a danger that someone breaks into your database, that is the training database, and just simply injects information here that's wrong. I mean, there's all kinds of potential for harm. And the problem is, you think about corporations, they want to rely on these systems. They want to replace people and put in AI systems and just rely on this stuff. And if the data there you can't rely on, then you have a double problem. You have fewer people, and now the people you do have are relying on information that's just flat out wrong.
So now let's turn to talk a little bit about data breaches
Mm,
and to help people understand what a breach is and what it is not, and to kind of frame this issue in some of our conversation going forward. And I think in your slide deck you included uh, an article that's available at the IPP's Privacy
mhm.
Advisor. And the article's titled "Is it an incident or a breach? How to tell and why it matters." And this is by Mahmoud Sherjan, and
Mm,
he's the CEO of Radar. And I believe you
mm.
know him. You mentioned that
Yep.
you guys worked in the same building, right?
Yes, yes, yes. When I lived back in Portland. Yep. Absolutely. So
So
yeah.
so let's
Um,
go through this. And Scott, what like the article? Why is this important for people to just
it's
generally as a cybersecurity professional? Why is it important to understand the difference between an incident or a breach or an event?
it's so important because if something is quote unquote a breach, as and I alluded to this a little earlier, is that there is a certain chain of events that must take place. For example, typically you must in all the contracts I've negotiated, I have to notify my supply chain members, my customers, my whoever immediately when a breach has been determined and immediately as in now. So I don't have a lot of runway when that happens. So determining that something's a breach has a very specific legal connotation, and it's something that you really have to take seriously. Also, this is great whenever you are developing tabletop exercises, determining whether something is merely an event, whether it's a true incident, meaning more likely than not something bad happened, or it's a breach where not only do the bad guys get in, but they also abscond it with data, whether it's personal or just any data for that matter. So you have to understand those gradations. They're not all one and the same, and each one's very important because if it's quote unquote an incident, it may be that you still have to report that to the authorities. If it's an incident that does not involve a breach, it may be that the integrity of your data is still a problem, but it's not necessarily the issue of having to notify people that their data has been stolen. I'll give you a great example. HHS says that if you have a ransomware attack, that's a breach. Even if no data that you know ever escaped, the fact that all of your data was essentially locked up, that's considered a breach. Now, some people may argue, no, that's not a breach because data didn't leave. It's just that the bad guys destroyed the data that was on the site. It's probably at this point is a distinction without a difference. The fact of the matter is that there's been a violation of the integrity of the data, and DHHS wants to know. So great example of that. So that's why you have to have a very, very good idea of what qualifies as a breach, because if you get it wrong, there's going to be litigation. And if you pay out big time, then there's going to be derivative lawsuits.
That's right. So just to walk through this, so you mentioned an event, and we have a definition here from
Hmm.
the CEO of Radar, his
Hmm.
article. Any observable occurrence in a system, so it could be sending an email message, so pretty benign stuff, right?
Hmm.
But then you have the a distinction of an adverse event and negative consequences, unauthorized use of system privileges, and unauthorized use of sensitive data. So that's kind of the first thing here in this deck. But then
Hmm.
you have where does it kind of cross the line to security incidents? And so something that violates an organization's security policy and procedures. Would you agree with that, Scott?
Uh, you know what? That for me, I think is not helpful.
Mm,
Okay. I mean, in my view, I like the one below it, okay, where
okay.
it compromises integrity, confidentiality, or availability. You can easily put your finger on that and go, yeah, our data has been the integrity of our data has been compromised because of ransomware. Okay. Bang, you got that. Whereas violating your security policies and procedures, I don't know. That's a little too loosey-goosey for me.
So the compromise integrity, so that's something that's like clearly defined. It's easy to for a business to know when that happens. Now we have what's a privacy incident. That's a little different, but
Mm-hmm.
we have here unauthorized use or disclosure of personally identifiable information.
Mm-hmm.
And it says that I think one of the important lines here from the article is most electronic privacy incidents are security incidents.
Mm-hmm.
Um, but not
Yes.
all security incidents are privacy incidents. And is that something you'd agree with, Scott? Or
Yeah, although keep in mind, and I will use the infamous example of Cambridge Analytica. Okay, there was never a breach, even though I know there's supposedly a documentary that calls it the breach. It's not a breach. Okay, it's a violation of trust. And again, there's a distinction there. Okay, bad guys didn't break into a server somewhere and abscond with data. Okay, it's just that data that was lawfully leased or licensed or whatever it is to Cambridge Analytica was used in a way that was outside the terms of the agreement. Okay, so it's a violation of trust. That's the distinction. And so yes, you can have a privacy incident that is not a security incident, and you can argue that it's common for private incidents to be misuse of data that was otherwise legitimately obtained.
so now finally we have data breach, and I think the article was pretty helpful in saying if a privacy incident meets specific legal definitions, and this is my thinking about it, is that it's really a breach is a legal determination.
Hmm.
And that it's usually state or federal breach laws that would determine whether something is or is not a breach. And is that your kind of understanding of it, Scott, based on your experience?
Yeah, but here's the thing is that you can have something that maybe doesn't necessarily reach the level of a state or federal breach, but still you're on the fence, and it may be that you're going to want to consider it a breach anyway, just out of an abundance of caution. So I would think of state and federal laws as the floor, but not the ceiling, certainly.
There we go. Okay. And so now we have this chart here, Scott.
Hmm.
I'm probably gonna have
Yeah.
to walk me through it.
Sure, sure. And
But
I know it's a bit of an eye chart, and I
yeah.
apologize. I tried to pack as much information as I could, and I may have gone overboard here. But the idea is under these laws or proposed laws, these are five laws that either are on the books right now, are coming online, or are, as I said, proposed. So, for example, I have here in purple the SEC rules that just came down. They went live in December. And I did that specifically because this was a sea change for, in many ways, and we don't have time really to discuss it, but sea change for how the SEC looks at breaches. And the threshold here is if there's a substantial likelihood that a reasonable shareholder would consider it important. Now, you may say, well, that materiality threshold, that is so subjective. But unfortunately, this is what we have to work with. And so you have to ask yourself, have I already done a tabletop exercise where we go through this and ask ourselves, is this material? Because that's the question we're going to have to determine very quickly whenever something bad does happen. So, a great example, and this is why I wanted to share this with you.
And so some of the
Yes.
definitions here, I see,
Hmm.
looking at it
Hmm.
and kind of running through it here, they talk about interference with continuity or security of
Hmm.
a vital system,
Yep.
that it interferes.
Hmm.
And so operational disruption in
Hmm.
another definition here, and
Hmm.
an attempt or success to gain unauthorized access. And
Hmm.
it seems like a lot of these definitions of breach, they have this unauthorized access or
Yes.
kind of they cross that threshold that's different than an abuse, or
Yes.
like somebody that's overusing. So it gets back to my wedding example where an abuse is some one person eating all the wedding cake.
Hmm.
But this is more of that threshold of I wasn't even invited and I'm trying to
Yes.
get into a system I wasn't invited to or that I wasn't supposed to have access to. Is that kind of the take? I'm looking at some of these definitions here. and it seems to be a good takeaway based on, what you've laid out here.
It is, and I think we have to be careful not to devalue the idea of a breach. And so if you look at all of these definitions, they all tend to revolve around the same idea that there's a compromise of confidentiality, availability, or integrity. From the EU standpoint, you'd probably add resilience as well, because resilience is now part of the CIA triad effectively. So those are the things that are addressed. Whereas simply, and I want to say, when I say simply, I'm not trying to minimize this, but simply abusing a site doesn't necessarily bring you into the realm of a breach.
Gotcha. That makes sense. So I'm going to jump now to our friends in Europe, and here is a definition. So let's talk about a personal data breach. And they said a breach of security leading to the accidental or unlawful destruction, loss, alteration, disclosure of, or access to personal data transmitted, stored, or otherwise processed. And to me, this definition seems a lot broader.
Much,
Um, and
much.
and what is your sense? Like, why would it be broader or
Well,
your
and when you see unlawful and disclosure,
mm,
okay, that's very easy. Okay. Also, again, you have the word unlawful, okay, and access to. Again, very easy. I mean, it's a very low bar to clear.
that's right. And I mean, looking at this, yeah, it seems to be a much broader definition based on that.
Hmm.
I guess it covers some of the purpose limitations,
Hmm.
and some of the other things. Let me see here. We have, this slide is interesting
Hmm.
because it talks about, what a breach is and the consequences of a breach. When you have a breach, it says the controller will be able to ensure compliance will be unable to ensure compliance with the principles relating to the processing of personal data as outlined in Article 5 of the GDPR.
Hmm.
And would you kind of agree to that? That to me sounds about right because if you don't have control of the data, if somebody is
Hmm.
taking it out of your system,
Hmm.
that may be you as a controller, well, you don't have control of the data,
Hmm.
so it's hard to meet your obligations under the GDPR. Would that kind of mesh with your understanding of a breach?
Yes. Yeah, absolutely. Because if you look at Article 5, it's all principles, including the principle of protecting the integrity of the data. So essentially, the cybersecurity piece of things. This is exactly correct.
Okay, so now we have uh they also have, I guess the European definition is a lot broader as well
Hmm.
because they also talk about data being unavailable as a breach,
Hmm.
which I don't think we really have that concept in US law, but I could be wrong about that.
Well,
What do you think,
it
Scott?
depends. It depends on how you articulate. Obviously, we have the CI triad, so we have availability as one of the legs.
Mm,
Okay, so you can argue that, for example, a DDoS attack.
yeah,
Okay, even though it's not a breach, okay, it still represents an attack that's actionable legally. So, is it a personal data breach? No. Okay, because you couldn't get access to the site here in the US. Now, in the EU, arguably the opposite is true. Availability alone puts you certainly in under the ambit of the GDPR because that's one of the things that is fundamental. If you can't have access to the site, they consider that to be a violation. Now, does that again, is that a practical definition? You can argue that it just creates more work without really helping anyone. Okay, if a site's not available, are you going to notify everyone that site's not available? How is that really advancing anyone's interests?
that's right. And it seems like, I mean, I can't count the number of times I've had a website or something that I needed to use not available or capture or something not working properly. And I personally didn't consider that a breach. But it seems like in Europe that something like that might fall into their much broader definition.
Yes, agreed.
All right, so now let's talk about, so Scott, do you know a little bit about this IEWG joint
Yes, yes,
statement?
yes. I've reviewed it a couple times now.
And so the IEWG, there's something called the Global Privacy Assembly, and the IEWG is the International Enforcement Working Group.
Hmm.
And so, and they issued a joint statement recently to kind of talk about data scraping and the protection of privacy. And so, let's talk through your understanding of kind of what they were saying and some of the takeaways for our audience here.
Well, what they were saying, and I'll cut to the juicy part here, is that they're suggesting that that scraping in many jurisdictions amounts to a reportable breach. And aside from, I think the rest of the document was very well written and well argued. I think this really they wound up stepping on their own message because they cite this idea that it may be a reportable data breach, but they don't cite any jurisdictions or cite any particular laws, and I don't think that helped them.
And so they also kind of talk about it here a little bit more, that mass data scraping may be constitute a reportable data breach in many jurisdictions. But I guess that's your point, is that saying, well, based on even in US law, that's kind of that might be tricky to, because if a breach is a legal determination here in the United
Hmm.
States, and it has certain criteria that usually involve
Hmm.
unauthorized access,
Hmm.
that it might be a stretch to call it a breach here in the U.S., or it may not be. It really isn't a breach here in the U.S.
Well, you think about what are you going to say that you have to say arguably that you want to call it a breach. Okay, great. What are you going to tell the authorities and what are you going to tell the affected parties? That a scraper has scraped data off the site, which happens basically every day and probably happens thousands of times a day and has been happening every day probably since the internet was started. So what are you going to tell the quote unquote affected parties? I mean, that this is the thing that I just don't agree with, is that I don't think this helped. I don't think this helped them. Okay, I understand the motivation behind this document, but simply saying this is a breach, great, this is going to be happening so often. What are you going to tell people that's going to be helpful to them? Unless we find a way technically to stop the whole scraping process, which is a different discussion, then this doesn't advance anyone's interests.
And I guess, a lot of the breach reporting statutes are, kind of, the burden is on the company. But to your
Hmm.
point, it seems like this happens so frequently,
Hmm.
and that companies, I guess any regulator will be overwhelmed with the reports of quote unquote breaches if people took this, that saying scraping was a reportable breach under their local laws in their jurisdiction. Seems like it would dilute what a real breach is, or what we traditionally think of a breach, where somebody hacks into a system and exfiltrates an entire database of information to, post on the dark web or something like that.
Yeah, absolutely. It does absolutely vitiate the idea of what a breach is. And a breach is a serious event. And this risks trivializing that. And I hope that they will rethink this, because a breach is, as I said many times today, it sets in motion a change of events. And I mean, I've spoken to clients in many cases where as soon as a breach is declared, then you call the insurance company, you tender you tender the claim, and you get panel counsel, and you get all of the wheels turning. You don't want to be doing that every time you get scraped. You could as I said earlier, you may be getting scraped 1,000 times a day. I hope not, but that may be the case. So you have to ask yourself, which battles you want to fight. And this is probably a battle you don't want to fight, at least from the notification perspective.
So now let's talk about, legal systems and addressing, seeing as this is kind of used, scraping is used a lot for, to build generative AI or to support those efforts. Let's talk a little bit about how legal systems are addressing AI generally.
Mhm.
And I know, this is a tremendous amount of information, Scott, but hopefully you
Mhm.
can take us through it quickly and, help people understand where the state of the law is when it comes to artificial intelligence.
In the US, and I'll just summarize as quick as I can, there's no federal privacy laws that address cybersecurity for AI in the private sector. Okay, full stop. We have a proposed law that's in Congress right now that would mandate the NIST AI risk management framework for federal agencies. Frankly, that's a no-brainer. I don't see that as an issue, but and it may be those agencies mandate that their contractors use this as well. Okay, that's great, but still not really something that is going to hit the private sector at large. However, what the federal government does have is the FTC Act, and simply a inability to protect personal data is going to be considered an unfair or deceptive trade act and would be punished accordingly. If children are involved, so much the better, because that it's one of the areas the FTC tends to really enforce very heavily, is when children's privacy is involved. So to the degrees that anything's considered unfair, deceptive, or involving children, then it's in terms of practices vis-a-vis scrapers or people abusing data, then it's something that's going to be punishable through those means, through unfair, deceptive trade practices. If we go to the next slide here, or do you want to comment on this? Team, it looks like Dave's computer crashed. He's going to reboot and get back on, but I can work from my slide deck if you like. Okay, then I'm going to share my slide deck here, and let me go to. Let me know if you guys see this. Okay, wonderful. So I apologize for that. Looks like Dave's system crashed. So, as I mentioned earlier, no U.S. Federal laws specifically addressing AI cybersecurity. So, for the state, unfortunately, same thing. No state laws that also address cybersecurity from AI at the private sector. However, the good news, if you want to call it that, is that almost all states have traditional cybersecurity laws. Like, for example, California, CCP 1798 talks about how businesses that possess personal data of individuals shall implement and maintain reasonable security procedures, etc. Also, there's the California Privacy Protection Agency, which is the privacy police, essentially, and they issue regulations vis-a-vis things like automated decision-making technology, which I'll talk about in just a minute. Okay. And then also we have state FTC equivalents. So I mentioned earlier about unfair business practices, et cetera, emissions. Same thing at the state level. And then state data privacy laws also address things like profiling, which arguably is part of the of what AI does. Also, automated decision making, definitely something that is part of what AI does. So also, state laws on the horizon. So we have this act in Connecticut, SB2, on artificial intelligence, and we're starting to see a lot more state laws that are now in process. They're going through the legislature this session, and this is an example of that. About the idea of having to implement risk management policies. You're going to find that almost all these laws are going to be mandating implementing risk management policies, and likely they're going to be addressing the NIST AI risk management framework as a consequence. Going over to the EU, this is really one of the things that I wanted the attendees to appreciate and understand here is how the EU looks at how AI is used. So, for example, the EU AI Act was just passed. It passed all the committees. It's got one more vote before it comes into law. That's actually this month, I believe, and next week is when it's going to get voted into. it affects two groups of people. So if you're inside the EU and you're providing or using AI technology, or you're outside the EU and the output of an AI is going to be used inside the EU. So that second one, they did, not surprisingly, to prevent people from circumventing the EU AI Act. Now, the Act applies to what's called high-risk systems. I'll dig into that in just a minute. So what the folks at the draft of the EU AI Act have done is they've created a four-tier system. And so essentially you start with things that have very little risk, like anti-spam technology or video games, and you move up the pyramid. And as more risk, there's more requirements. So if you have AI applications, like for example, the ones that can generate deep fakes, you have to label them. So there's a transparency component to this. If you reach the level of high risk, meaning that it's critical infrastructure like our utilities or our digital infrastructure like the internet itself, law enforcement, things that you really want a lot of scrutiny about how AI is applied or implemented, then it's considered high risk. Probably 90% of the EU AI Act is wrapped around high risk applications. And then finally, you have the unacceptable risk, which is things like screen scraping and grabbing people's information and then using that for biometric identification, i.e. what essentially Clearview AI was doing. So great example of that. In terms of mandates, you have a couple sets of mandates here. You have the Article 9 mandates, which is the risk management system. You're going to see, as I've said many times, risk management tends to travel with cybersecurity. The idea is that you want to be able to assess something and continually reassess it as it's being implemented to make sure that nothing bad happens, and then to protect it cybersecurity wise, that's Article 15. And then finally, there's another hurdle. It's the conformity assessment, almost like a safety test. Here in the US, we have this idea of a good housekeeping seal of approval. Think about that writ large. That's a conformity assessment. And in fact, you'll recognize the little conformity assessment symbol that I'll share with you. So a couple things about the EU AI Act. You have this risk management system, and you have to first assess a system before it even gets placed into the market. Now you might ask, well, what do we use to do that? Well, right now we've got the AI RMF. We also have an ISO for that, 23894. That's designed to also address the idea of a risk management framework. Article 15, this is the kernel essentially of the, if you will, of the requirements for cybersecurity. So you have this idea of a system that is going to be robust and resilient. This is interesting, is the first word they use is not necessarily secure or CIA triad, it's resilient. And I find that fascinating that they actually brought resiliency to the fore. Then on the next article, they talk about resilient versus third parties. So again, there's this idea of resiliency. And then they say that the controls have to be appropriate, which implies that you've had a risk assessment. Also, they actually cite very specific things that you have to address. And they also tell you it's not enough to prevent, detect, and respond to. You have to be able to resolve and control for attacks. That's something that really, I think, was missed by a lot of the analysis I've seen thus far, that not only do you have to prevent it and respond to it, you've got to resolve and control for it. Finally, there's specific things that they've cited that they think are particularly important. That's data poisoning, and that is model poisoning, same idea. And then the idea of tricking an AI, adversarial examples, or model evasion. So imagine tricking an AI automobile, for example, to misread a stop sign and to not stop, for example. And Dave is back. Dave, do you want to take over from here, or what would you like to do?
Yeah, I could take over from here. Apologies, everybody. My computer decided I needed a break. But great to be back on with everybody here. And that's the challenges of technology sometimes. But thank you, Scott,
Of course.
covering that while I was in restart land.
Good.
So let's see here. I think we are on slide 37.
41.
Oh, 30.
I've got 41. Well, I'm using my deck right now, so
Gotcha.
um,
41. No,
yep.
that works. Okay, so we just talked through the EU Act mandates, and I guess now we can kind of go to the standards and guidelines for Article 15, right?
Hmm.
And what's on the
Yeah.
horizon.
essentially, hate to say it, there are no standards at this point. And in fairness, this is such a rapidly evolving area that not surprising that there's no AI specific cybersecurity standards. So the good news, if you want to call it that, is that they're on the way. In the meantime, ENISA, which is, think about CISA, but it's the European version of CISA, they've said, and not surprisingly, ISO 27000 is a way to go. They've also suggested some other ones like ISO 9001, which makes sense because integrity is especially important.
Great. And
Also,
can you say something about conformity assessments here?
yeah, let me go over to CAs. So you've almost certainly seen this CE symbol if you've bought a piece of equipment, especially electronic equipment. Oftentimes it'll have the CE symbol on it. Essentially, that is something that's passed a safety test. Okay, and I know I'm probably underselling this. It's actually a pretty elaborate process, but this is the kind of thing that AI systems will now have to go through as well if they're high risk. So definitely something to think about that as part of your risk management system and your product development system, you're going to have to think about with an eye to reevaluate and re-perform a conformity assessment periodically.
And then the conformity assessment in InfoSec, I'm
Hmm.
looking at the quality of data sets and I'm
Hmm.
seeing, gee,
Yes.
you're using scraped data. Is that high quality data or?
Yeah, I'd say no. So, this is a great. I want to give a shout out to Future Privacy Forum. They gave a great laundry list of things that CAs have to incorporate. So, yes, quality of data sets, arguably just as important as cybersecurity.
Great. Okay. And we have a few other things, human
Yep.
oversight, robustness, accuracy, and
Oh.
cybersecurity. So a lot of good information on this slide
Hmm.
for people to look at
Yep.
after the session here.
Yep.
Um, and then what about this on May 22nd, 2023, the Committee for Standardization, and why
Yep.
is that important?
It's important because we need standards and we need them now. So the EU's asked two EU-centric body standards committees to develop policy, to develop standards essentially for everything, including risk management, governance, and cybersecurity. And you can bet that something to the effect of protecting data, the integrity of data, training data, and so forth, that's going to be part of that. It may cover several of these. So they have until next April to be able to deliver that. Until then, we're largely on our own.
Great. And then this is my favorite slide. Let's talk
Hmm.
about fines and
Yeah.
when it goes into effect.
So roughly 24 months from now, which doesn't seem like a particularly short runway, but think about how we're going to be waiting for standards for at least for another year. So it's not quite as big. Also, it's not on this list here, is that if you have a general purpose AI, GPAI, that's applicable 12 months from now, unless it's already in service, then it's 24 months. So generally speaking, 24 months. High risk systems, to the degree that your system is a high risk, it's 36 months. But again, you're going to need all that time because the scrutiny is going to be intense, and penalties are going to be severe. The kind of penalties that Clearview AI was involved in, the kind that will foster up to 35 million or 7% of your global total revenue. So they're going to be pretty painful when they come down, and I expect them to be just as robust as the ones against companies that violate the GDPR.
Yeah, there seems to be a higher number than the GDPR numbers. That's interesting. 7%. That's very painful. I'm sure. Hopefully, I guess we'll see some of that in the coming years.
Yes,
Like the
undoubtedly.
GDPR, that'll probably take a little while for that to get ramped up.
Exactly. Yeah,
People can
we'll see
start
this.
getting fines.
Yep, we'll see the same model. Exactly.
So now let's talk a little bit about legitimate interest as a legal basis for using scraped data under the UK GDPR. And so recently there was an ICO consultation. Again, that's the regulator for privacy in the UK. And they asked some questions about generative AI and what could be a lawful basis for web scraping to train generative AI models. And just really quickly, Scott, can you talk about the difference between US versus EU and their lawful basis model versus US where
Where
it kind
where
of
there is
doesn't.
no there is no need for a lawful basis. Yes,
Yeah.
yes, the EU requires, and this is a threshold matter, that you have to have a legal right to process the data in the first place. Otherwise, you can't do anything else. Full stop. And there's actually two two requirements. One is for processing data internally. Another one is to have a lawful basis to transfer it overseas. It's easy to miss that there's a second one for transferring the data overseas. There is nothing like that here in the US. The closest thing we have is that if you have, for example, medical data, or you have data from a minor, then you, in many cases, have to consent to its processing. But that's it. That's the closest thing we have to the idea of a lawful basis. And it's something that in my view, we desperately need here in the US.
And so it seems like in the ICO's consultation, they were kind of suggesting that uh, legitimate interest is one of the lawful bases enumerated, just like consent or contractual necessity could be a valid lawful basis for training generative AI models on web scrape data. Scott, do you have anything to say about that or thoughts on that position?
Yeah, I agree. It could be a lawful basis, but I think it's going to be a bridge too far. Simply because the balancing test that's involved in a legitimate interest is just too difficult to make an argument that yeah, it could be, but actually fulfilling those requirements, I just don't see it.
Well, I'll go back to Scott, your slide
Hmm.
about guidelines on personal data breach
Hmm.
notification, where it says,
Hmm.
the controller will be unable to ensure compliance with
Hmm.
the processing of personal data. And
Hmm.
so, if you can't, if you can't control or you don't have access to or you don't have say over how the personal data is processed, how does that work, or how is it meeting any of the legal bases?
It's it's
Um,
very difficult to see how you meet any of the legal bases, especially legitimate interest. And at the risk of editorializing here, I think the problem with legitimate interest is that it really was designed specifically for a balancing test, and it's that balancing test has been ignored, and simply it's become a default that when someone does not know how to get permission to get a legal basis or to otherwise get a legal basis, they simply fall back on legitimate interest. That's not what it was designed to do.
And it seems like the ICO, just on this next slide that you included, was
Mhm.
they're saying that as controllers for the generative AI model training, developers need to
Mhm.
identify legitimate interest for
Mhm.
processing the web scrape personal data in the first place. I
Mhm.
mean, how many entities that are scraping are actually saying, "Okay, I know what I'm going to be doing with this data,"
Uh,
or in that ecosystem?
I suspect zero.
Yeah, that seems to be a an issue. And it seems like the ICO recognizes
Mhm.
this. They also say in their
Mhm.
consultation, the key
Mhm.
question is if you don't know what your model is going to be used for, how can you
Mhm.
ensure its downstream use will respect data protection and people's rights and freedoms? But isn't that
Mhm.
true with the scrape data that's
Yep.
being used in the sense that this is one step removed. You have scrape data being
Mhm.
train a model
Yep.
that then people aren't sure because these models are very general purpose what they're going to be
Mhm.
used for.
They,
So it seems to me, or that legitimate interest just doesn't work in this context. What do you think?
I don't see how it can work because remember, one of the legs in the stool of legitimate interest is the benefit to the user of the data of somehow outweighing the benefits or the detriment to the individual. And I mean, arguably, the individual's rights are being violated without any benefit to them, or benefit only to the user of the scraped data. I don't see how you ever escape that hurdle.
Now, there's another consideration here. The Court of European Justice, their
Hmm.
data protection ruling for
Hmm.
behavioral advertising, and
Hmm.
just looked at this. I guess the takeaway was that a platform using their own data on their own
Hmm.
site could not claim legitimate interest as a basis for processing that data for behavioral advertising.
Hmm.
So, I mean, how does that mesh with an idea to use legitimate interest as a basis for using scrape data for training models?
I just don't see how you could ever use it because how does the person whose personal data you've just scraped, how do they know what's going to be done with the data? I mean, they when their data, presumably they put it up there for a reason or allowed to put it up for a reason. The idea that it was ever done with the idea that someone could come along, scrape it, and then basically do whatever they want with it. It's just there's no way that that's going to qualify as a legitimate interest of the scraper. I don't see any way around that.
That's an interesting point. So now let's turn to the NIST Artificial Intelligence Risk Management Framework, and I think we've kind of talked a little bit about that.
Hmm.
Let me turn to that right now.
Hmm.
So we talk, the background is that Congress required NIST to develop a framework, and it's a voluntary resource for organizations designing, developing, deploying, or using AI systems.
Hmm.
And so, how helpful has it been in your practice in using for people trying to deploy AI systems or understand their obligations and how they should be using data or how they should be managing training sets or how they should be managing data collected at the prompt?
It's been invaluable in a nutshell. And this had been in development for quite a while. It's interesting that this was issued the month after ChatGPT was issued. So I believe it was just in what, January 2023, and it was a month or two before ChatGPT came out. So it came out at a very auspicious time, and it does a fabulous job of encapsulating all the considerations for AI, and in particular, an entire, if you will, life cycle that we'll talk about in a few minutes.
And I guess one important thing is to talk about is the harms,
Hmm.
that the potential there for harms. And could you walk our audience through
Mm.
this slide that actually is
Mm.
a reproduction from the NIST
Yeah.
materials?
Yeah, that we drew this from this materials, and it asks you to consider the harms at an individual level. So not just to an organization or to all of mankind, if you will, but to harms to individuals. So what's going to happen if you take this person's data and process it with an AI? What's the potential that that person's going to be harmed in terms of their ability to get a job, or their ability to get government benefits, or just to interact with other people in society? The potential for harm is substantial, and certainly I don't know if even NIST envisioned how big that was going to be. But again, we've seen that some cases with celebrities being defamed, etc., recently, that they were spot on when they talk about harms to people.
Now we have the audience or AI
Hmm.
actors, and this is
Hmm.
another helpful infographic from NIST. And can you walk us through especially the life cycle stage? I have a
Yes.
box highlighted in red for our audience that may be hard to see or looking at this on their phone.
Yeah, I know that this a super eye chart. Hopefully, NIST will make this a little bigger, but the net of it is that you can think of these seven stages really as the life cycle for AI development. And then within each stage, you're going to have different players. You're going to have the people that actually do the coding, people who do the designing, the governance component of it, the cybersecurity component of it, the privacy. So you're going to have all these different actors and their respective activities. And I mean, this is worth the document itself, just going through this section here. And you can see from left to right, from planning and designing all the way to deploying it, and then people are becoming used in or otherwise impacted by it. This is the idea that this is a cycle, and that you have to think about all the steps, and that as you get to the end, then you come back to the beginning and say maybe it's time to change the plan or change the design to make sure that based on our feedback, we're adequately protecting people's personal liberties.
And so we also have some within the NIST documentation characteristics
Mhm.
of trustworthy
Mhm.
AI. And
Yes.
can you talk through this infographic?
Sure. And there's a set of criteria or characteristics that they believe, and I think are consistent with everything we understand, that are characteristic of trustworthy AI. Because remember and I've mentioned this a couple times, is the idea again of trust. It's interesting how this dynamic plays through. It's not just something that is internet centric. It's in our entire lives. The idea of, can you trust AI? And we've seen a lot of incidents over the past year or so where it's clear that AI probably is not getting it right. So these are the characteristics of trustworthy AI, not surprisingly, one of which is secure and resilient. Again, there's that word resilient. That's not an accident. Resilience is now the fourth leg of the CIA triad, essentially. And here it calls it right out and talks about that resilience is not just better availability, it's the ability to take a beating and return to normal function. Whereas security is resilience, but it also has other components as well, vis-a-vis attacks. So this is gold. This is worth, again, the document, just reading it just for this alone.
And now we have the crosswalk of the
Hmm.
NIST AI RMF, the
Hmm.
OECD, the EU AI Act,
Hmm.
Executive Order 13960, and then the
Hmm.
blueprint for the AI Bill of Rights.
Sure.
And again, another red box. Help us understand this infographic.
What's common to
Start.
all of these, and they share a lot of principles. This is what I like about these different manifestations of protecting individuals, is that they have a lot of common characteristics. One is consistent, and that is secure. So I think that's important, is that any model or any way of developing AI, security is always going to be a major component, and they may couch it in different terms. They may say secure and resilient or what have you, or just cybersecurity resilient. But the idea is that it's going to be both secure and resilient.
Now, in the AI RMF, they have several core functions: map, govern, measure, and manage.
Mhm.
I guess I'm going to skip to this slide here. Can you talk us through those?
Sure, sure. And in fact, I'll skip to the next one because I think it actually does a better job. So govern is the center of everything, and you're seeing this in all the um, NIST documentation that talks about things like the cybersecurity framework or privacy framework. Is they talk about governance now as the core component, and everything tends to orbit that. So hence why the graphic looks like this. When we talk about govern, we mean what's the structure? Who ultimately has a say about what gets done or what does not get done, versus map, which means, do you have this idea of what we call proactive intelligence? You've got the sufficient information to say go, no go. And a lot of these AI systems that we've seen in the public probably should have gotten a no go, just based on what we've seen. Measurement, meaning you have the telemetry to measure what is actually going on with your model and whether it's operating according to plan. And then managing, which means that you prioritize what needs to get done because you're going to find all kinds of things and you're going to execute accordingly. That's it. I mean, this is a great way to look at managing AI. And again, it's very, I think, characteristic of how NIST views the world.
And now, Scott, on your deck, you
Mhm.
have an example of some of the core functions. Can you
Mhm.
walk our audience through that?
Sure, sure. I put govern because govern again is the core, and it's something that's going to be in any kind of document that is going to address AI lifecycle. So here you have the idea of, do you have the structure in place, and then within the structure, all the little things that make up the whole. So do you understand your legal and regulatory requirements? Do you understand the characteristics of trustworthy AI we talked about earlier? Do you have the processes and procedures, et cetera? So do you have all the components to steer the ship that is an AI development?
And so now we're going to talk about one of my favorite documents from this, the RMF playbook.
Hmm.
And I think the playbook is kind of the user guide for the AI RMF.
Hmm.
And it kind of does a lot of crosswalks and makes it very usable for somebody just kind of looking at this stuff to actually, open the playbook and say, well, how am I going to approach these issues? How am I going to think about them? Is that your experience with the playbook, Scott?
Yeah, playbooks are excellent. Again, this is characteristic of what NIST is been doing and why I just really like their work so much. So you think about a playbook is that, and this screen doesn't do it justice. I really encourage our viewers to go to the NIST site, to the playbook. You can literally plug in the things that you're interested in. Say that you're only interested, for whatever reason, just the cybersecurity aspect. You can plug that in, and then it'll give you a playbook for all four components of the framework respectively about what needs to be done. It'll create this list, and then from there you can take that list as a to-do list and use that to be actionable. So it's excellent, highly recommend it.
And it seems like just on this slide here,
Mhm.
it mentions suggestions
Mhm.
are aligned to each subcategory, but that they're
Mhm.
voluntary.
Mhm.
And I guess we can kind of go to the next slide in your deck, which is
Mhm.
an example
Mhm.
for example, under govern,
Mhm.
legal regulatory requirements involving AI are understood and
Mhm.
documented.
Yep.
And then it kind of talks through AI systems may be subject to specific applicable legal and
Mhm.
regulatory requirements. Some legal requirements
Mhm.
mandate
Mhm.
documentation, disclosure, and increased AI system
Mhm.
transparency.
Mhm.
I mean, and like, for example, this next slide, it goes through it within the
Mhm.
playbook, it would go through under
Mhm.
this particular element. it kind of asks a series of questions.
Mm-hmm.
And so it's saying, like, to what extent has the entity
Mm-hmm.
defined and documented the regulatory
Yep.
environment, including the
Mm-hmm.
minimum requirements in law and
Yep.
regulation? Has the system been reviewed for its
Mm-hmm.
compliance? To
Yep.
what extent has the entity defined and documented the regulatory environment? Has the
Mm-hmm.
system been reviewed for its compliance to relevant
Mm-hmm.
applicable laws? So it seems to me that this is a great list of questions to sit down, and when your product team comes out with
Mm-hmm.
a new product, to kind of run through
Mm-hmm.
this and say, well, where are we, and where is this being deployed,
Mm-hmm.
and how should we think about it, and what regulations apply to
Mm-hmm.
this new AI product or service that my
Mm-hmm.
company is rolling out.
Yes, and what I like about this is that it really, if you use this, it's going to force you to ask those questions. Presumably, it's going to require that legal and the product development team work very closely to make sure they're not missing anything.
That's right. And so now InfoSec and NIST AI RMF, what some of these questions, Scott, that you put together,
Mm-hmm.
what kind of things should people be considering as they kind of look at these things together?
Well, I mean, just from the very beginning, what data is to be collected for training sets? Okay, I would be very reluctant to take scraped data as something that it has the quality that you require to protect the integrity of what's going to be coming downstream. This is why this decision is so important, because once you train a model, it's very expensive to have to go and retrain it. So you have to get this right the first time. Otherwise, you're going to be wasting a lot of money retraining a model because your original data just wasn't what it should have been. The integrity just was in question. So that really has to be so important. Then you have to ask yourself these other questions. And these are, and I borrowed these from NIST. So things like, it's very people centric. Does it rely on or generate data about people? Well, yep, that sounds typical. Does it have humans engaging with people? It sure does. And does it inform human decision making? Unfortunately, it does. I think there's a lot of over reliance right now on generative AI for making decisions when probably we're not ready for prime time yet.
So now, where does InfoSec fit? And you say just about everywhere. Yeah,
Just
let me
about
walk us
everywhere.
through this one. I agree. But please help our audience understand this a little bit better.
Literally, in of the 7 parts of the life cycle for AI development, in 6 of them, cybersecurity, InfoSec is relevant. That should really tell you something. That especially in planning and designing, I mentioned earlier, because it's so important, but also collecting and processing the data. Great. Where are you getting that data from? And when your data is collected, how is the integrity of that being protected? Even if someone damages your data by accident, it's still damaged. Okay. If it's still mixed with something that it should have been mixed with or what have you, then it's still damaged. Doesn't matter that a bad guy didn't do it. It was done by accident. So the integrity of that means that access controls have to be at a premium. So it's a great example of why InfoSec, it has to be involved in so many things. And my guess is they probably are not nearly as involved as they should be.
So now we have a sample of
Mm-hmm.
from the RMF, and it kind of talks through, for example, the plan and design phase. And can you
Yes.
just walk us through one of these charts to help people
Yeah,
understand
sure.
how they can use
Sure.
this?
Absolutely. And actually, I plugged in cybersecurity and into the playbook and then drew this from the playbook. So this is a good example of this. And you can see if you're planning and designing, you're asking yourself, okay, how are we incorporating security by design into everything? And then you can look at this is largely a governance issue, but it's also a measure issue, meaning that you have an ability to say, yes, we have the telemetry we need to know that we've done things right. And so whenever you look through this, you'll see, are we addressing availability, confidentiality, integrity? So it's again forcing you to address the specific issues and then cross-referencing things like, can you measure how much availability, how much confidentiality you have, etc. So it's a great way. It really just, it forces you to find the data and determine, yes, you're doing it right, or no, you're not. It's not just something that's going to be very hand wavy and say, yeah, we're on it. You actually have to show your work.
And for something like
Mm.
collect and process data,
Mhm.
how would one work through this slide?
Same principle. You ask the question here they've put, okay, so how is the security of the training data created or ensured? Okay. Well, once you answer that question, again, you know it's a governance issue, you know it's a mapping issue as well. So you want to be able to say, yes, we have the proactive intelligence necessary to say go, no go, we've done this correctly. We've measured it by testing it out and saying, yes, it really works according to how we think so. So this is so important that when you're collecting and processing that data, you're really getting a very good idea of you have a system for doing so, and you've protected the integrity of this so that you know if something's been breached or bad guys have somehow gotten in or mistakes have been made and the data is no longer useful, you have a tool to be able to test that. That's part of the idea of measuring.
Great. And then build and use the model. How could somebody use this chart that you prepared?
It's asking, how do you keep bad guys out? Or how do you keep bad code out? How do you keep Trojans or other malware out? How do you address whenever you think that there's an attack? How do you document that so that maybe something that you document it, you look back 6 months ago and you realize, you know what, we thought that that was an event. It really was an incident. Somehow the bad guys got in, or somehow bad data got in, and now we're just realizing that. By having that documentation, you can look back and look for patterns.
And this seems to be heavier on the managed side than the governance or mapping side or measurement side. Is that
Yes.
a good
Well,
pick?
it's actually very measurement centric. This is why I have it in bold. So, but I mean, all of these are relevant. But if you're short on time, you're going to go right to the ones in bold. In this case, measurement, meaning that you're finding an ability to quantify how you're protecting against malware. Perhaps you're looking at all the alleged attacks that are coming through, and then determining that nothing actually got through, for example.
Great. And I think we'll skip ahead
Okay.
to a scraping scenario
Okay.
with the NIST RMF and trying to use this to a few scenarios just to understand uh,
Mm-hmm.
how we can apply the risk management framework to data that's scraped or managing your training sets. And so, first scenario, unauthorized web scraping prevention and management. DataSec AI is a cybersecurity company that provides web scraping detection and prevention services. It utilizes AI to monitor and protect its client's website from unauthorized data extraction. XYZ Corporation, a client of DataSec AI, operates on an online marketplace with sensitive vendor and customer information. XYZ has been facing issues with competitors and data thieves scraping their site, leading to a loss of competitive edge and potential data privacy concerns. XYZ Corporation, being subject to federal laws that include stringent data protection regulations, needs to ensure the protection of data from unauthorized access and scraping activities. So, Scott, how would they use the NIST playbook and the AI RMF to kind of examine this issue? And I kind of, as a cheat sheet, I thought
Mm-hmm.
that maybe we could start with something like mapping
Mm-hmm.
and
Sure.
look at that.
Sure. Again, when we talk about mapping, we're talking about proactive intelligence. So the question is, do we have enough intelligence to be able to make intelligent decisions, quite literally? So the idea here is that, and we'll go back a slide real quick. So we have DataSec AI. They're providing this detection and prevention service. So the question is that the information that DataSec is being able, presumably they're putting some kind of a tool on XYZ site. Okay, XYZ for whatever reason can't password protect the site, so or otherwise there's not they can't use authentication to stop this. So now DataSec has this tool that's going to be able to provide intelligence, say, yes, this scraping it happened in this form, it came from this place outside the country, it involves this much data was taken. Basically, by getting all of this proactive intelligence, you can then say, okay, great, we have a model now of what trouble looks like, and then we can develop countermeasures specifically to keep those attacks or at least mitigate them to a degree that's manageable.
So it goes back to that understanding the context of where
Mm-hmm.
the application, the AI tool is being deployed is something that an entity needs to consider.
Yes.
And it's true with also the data that is being used. What is the
Mm-hmm.
context that data is going to be used in? So now, if
Yes.
we were to jump ahead to suggested actions on
Mm-hmm.
mapping, I think
Mm-hmm.
you see here define and
Mm-hmm.
document a task, purpose, minimum
Mm-hmm.
functionality, look at if there's other technology available. But
Mm-hmm.
again, it goes back to your point earlier, examine
Mm-hmm.
trustworthiness of AI system and
Yes.
consider non-AI solutions, which I'm sure many people that are very pro AI would not want to hear, but that's what NIST is suggesting under that
Yep.
particular function.
Yeah. Not everything needs to be be in LLM. I mean, quite frankly, just because you can doesn't necessarily mean you should.
Now we also have transparency and documentation, and this is also under that map,
Mm-hmm.
that mapping
Mm-hmm.
item. And it says, organizations can document the following and
Mm-hmm.
talk through what extent does a plan specifically address risks associated with acquisition, procurement of packaged
Mm-hmm.
software from vendors. And that's
Sure.
all stuff. Are they using scrape data? What
Mm-hmm.
data sets are they using? How are they
Mm-hmm.
training their models? And
Mm-hmm.
those are all the kind of questions that you would want to ask in this scenario.
Agreed.
And then I guess another thing is who is, and just going to the bottom here, who's the person accountable for the ethical
Mm-hmm.
considerations across the AI lifecycle? So all of these great
Mm-hmm.
questions within the playbook for companies to
Mm-hmm.
use. I mean, is that your experience that your clients are kind of getting a lot of value out of the NIST products?
Yeah, I mean, NIST, I know I sound like a NIST fanboy here, but this has really been thought through. And NIST did this before generative AI became popular. I mean, they've been working on this for a while. And to their credit, the EU was working on the AI Act long before generative AI became popular. It just happened to be that these things that they were working on happened to be especially relevant once generative AI came onto the marketplace. Then suddenly everything got turbocharged and these got pushed to the fore, which is good. So yes, this is a great tool to use, and it will serve you well.
And now we see here is another part of it,
Hmm.
looking at the measure
Hmm.
privacy risk of the AI system as
Hmm.
identified in the map function that we were just
Hmm.
looking at,
Hmm.
is examined and documented. So this is
Hmm.
the recommendations. Uh,
Hmm.
and so some of the things, the suggested actions that they include
Hmm.
under this measurement
Hmm.
item,
Hmm.
establish and document protocols and access controls for training sets,
Hmm.
production data containing personally sensitive information.
Yep.
So here you see the, I guess my takeaway on this is that they are thinking about training sets, they are thinking about what's going into them, and they are thinking about who has access to training sets. To make sure that the data collected is used for the purpose
Hmm.
that was collected for.
Yes, the integrity of the use the training set. It's a great point because the idea is that you've got this training set, assuming that it works successfully and you've got a great product, but when people have their data scraped, they certainly may not have been anticipating that any of the things you're going to be planning on doing with it, vis-a-vis the training set and the model, actually are going to come to bear. So it may be that you've done everything correctly, but it's still something that when you ultimately deploy it, find out that it's not working the way people expected because they didn't have any expectations to begin with, so they were surprised to see what it could do. So again, it's speculative, but it may be after all the work you do on here, you have to go back and make changes regardless.
And now that was the suggested actions under
Hmm.
this element, but now we have the
Hmm.
transparency and documentation
Hmm.
and what the organizations can document. Oh, sorry, jumped one ahead here. And so just basics, did your
Hmm.
organization implement accountability-based
Hmm.
practices in data management and protection?
Hmm.
And so I think a lot of these are, I mean, in your experience, Scott, people are finding
Hmm.
these valuable to these the documentation recommendations as well.
Yeah, I mean, you have to have this stuff documented because if there's ever litigation or some kind of regulatory action, and they ask, well, we have stories or we have testimony that people knew there were problems. Where's the documentation? If it's not there, then that's going to not reflect very well that there was known problems and it simply wasn't documented because we didn't want the accountability that's being asked for here. You have to be able to have that direct line from, hey, it doesn't work, to someone saying, hey, go fix it.
That's right. And now we had a second scenario, but we're about a
Mm,
half an hour over.
okay.
So I think, I mean, we could go through it at a very fast here, high
Oh,
level.
okay.
Scenario two, unauthorized data detection in AI model training. So another
Hmm.
scraping
Hmm.
scenario, just to help people walk through the NIST RMF and understand
Hmm.
how to use it
Hmm.
for your own entities. And when you're as a member or as a company out there, to understand how you can use this to deal with the issue of scrape data and training set integrity and
Hmm.
training set lineage. So here we have Model Check AI is an analytics company that
Hmm.
specializes in auditing AI models for compliance with legal and ethical standards. One of
Hmm.
its services includes checking for the presence of unauthorized data within its AI training data sets.
Hmm.
Beta Tech Inc., a client of Model Check AI, is a tech company that develops AI driven recommendation engines for e commerce platforms.
Hmm.
Beta tech sources vast amounts of data from various online sources to train their models, which
Hmm.
raises concerns about the potential inclusion of data scraped from competitors or other
Hmm.
sources without proper authorization. As a
Hmm.
company operated under stringent data usage laws and intellectual property rights, Beta Tech must ensure that none of the data used to train its AI models comes from unauthorized scraping activities. So, another pretty meaty
Hmm.
vignette here
Yep.
to kind of help us understand how to use the NIST AI
Hmm.
RMF. And let's just jump right into it, Scott.
Okay. Okay.
You have here in your deck MAP 2.3. What's
Hmm.
the relevance of that one?
Again, remember we talk about mapping, and this is the idea that you have that proactive intelligence, and I use that phrase a lot because it's the idea that you're able to look down the road and get the information you need to make correct decisions. So it talks here about scientific integrity and TEV, testing, evaluation, validation, verification, considerations. So you've got all of this information, or you're gathering it to be able to determine, yes, we are where we think we need to be, or no, we don't have the right information, or we know that we're in the wrong spot. We need to take a step back. We need to go back one and start over again or make changes. So being able to have that's critical, and that's why you'll see the phrase TEV a lot, because it's part of how NIST talks about things, and this constant idea of testing and evaluating and making sure you get that intelligence so you don't go too far and train on terabytes of data and then have to start all over again.
So now, if I look under the suggested actions for this particular element here, it talks about, for example, identify and document processes to understand and trace test and training data lineage. And
Mhm.
just for our audience, what's data lineage?
It's the idea of being able to go back to the source of where the data came from, and validating that you legitimately got it and that it was legitimately transferred and the integrity has been maintained. It's almost like a chain of custody, but also with the idea that you knew exactly where it came from and that it was legitimately obtained.
And so then just right below it, it says is suggested action from this is
Mhm.
document known limitations, risk mitigation efforts associated with and methods used for training data collection, selection, labeling, cleaning, and
Mhm.
analysis. So that sounds like all of the
Mhm.
things that you would want to do with your training set and
Mhm.
understanding where it came from and what
Yep.
its composition was.
Well, not only that, being able to put a report together. Suppose that you have an authority that investigates you and says, "I want a lineage report of your training data." And if you can't produce that, or maybe you kind of got it from a shady source that said, "Hey, I've got some public source data here, here, I'll sell it to you," but not really vouching for whether they got it legitimately. And we had this discussions when GDPR came out, then you really can't use that data. So not having that chain of custody, as I call it, is detrimental to say the least.
Now, trying to move ahead to controls, a topic near and dear to my heart.
Mhm.
Can people use controls for governance over their AI systems or systems they're purchasing or systems they're developing?
Yes, in fact, I think you have to use these controls, especially in the governance component of it. You have to, and whether those controls are simply, and I'm not, again, not minimizing it, but simply policies and procedures, getting someone to sign off on something and saying, yes, we can do this, essentially an authority to operate, for example. So I think that's critical, and this is the phase in which you're going to do that.
Now, some companies I know are, I imagine are struggling even with basic GDPR privacy
Mhm.
controls or privacy controls,
Mhm.
period. But I mean, I guess there's a lot of resources out there,
Mhm.
Scott, that you that are published privacy controls that you could also use to look at your AI system. And
Mhm.
for example, like why would it be important to have a control around a privacy policy when you're deploying an AI service or an AI platform?
Well, you want to make sure that anything you're deploying is consistent with that policy, and that is the policy capable of being enforced, and what's the potential penalties. Again, if it's a policy that someone can't be punished for violating, it's not a policy, it's just happy thoughts. So you have to ask yourself, one, is it truly a policy? And two, is your development consistent with that policy? And is there someone minding the store and checking that? Or is it just the shelfware that you've developed and you really are not using?
And I see that here are some of the controls that are included, and I think this is the NORIA control set.
Mhm.
PP001, a documented privacy policy which has been communicated to internal personnel and external stakeholders, has
Mhm.
been established and is reviewed and approved annually by
Mhm.
management. So that all seems very basic stuff. But how
Yep.
many companies fall flat on getting this done, either for their AI products and services or just generally?
I think just generally, I think probably more than not are falling flat on this. I mean, there's so many policies the companies have, and the idea that you're going to be able to review them yearly, it doesn't happen.
Yeah. But a control like this that's tested on a yearly basis certainly would
Mhm.
identify that kind of an issue before a regulator finds it, right?
Agreed. Agreed. Absolutely.
So now we have data identification and classification. I think we kind of touched on this earlier.
Hmm.
And so another just standard control that's out there that would be helpful to use for AI systems,
Hmm.
um, that the entity deploys a documented process to identify and document the processing of personal data and classifying
Hmm.
that data as such. So how is that
Hmm.
relevant to scrape data and training sets?
Well, you have to be able to associate or segregate or identify what data in your training set is considered personal data. And I know that's a very subjective term because different cultures are going to call something personal versus not, but you have to have something to work with to be able to say, yes, we've put special controls or additional controls around data considered personal versus data that's considered non-personal. Okay, so if data is merely statistical data, for example, probably not personal, but it's going to get fewer controls. Personal data, it's going to get much more scrutiny because of all the bad things that can happen.
And so my experience as a company, and it might be different from the privacy team, or if you have a smaller team, they might have a lot of
Mhm.
overlapping functions, but they would take a control set like this and they would test them on a regular basis to make sure that they're in compliance. And is that your kind of experience too, Scott, based on the companies you work with, or how are they doing things a little bit differently when it comes to AI controls or privacy controls in general?
If they're doing things right, yes, they're absolutely testing, especially for personal data, to make sure that they're literally spot checking to make sure that they've identified correctly that the personal data they think they have is what they really have, as opposed to getting surprised down the road and realize they were training on a lot more data that they didn't realize was personal.
Now, another resource that's out there is the Musa industry practices. And I
Hmm.
think, Scott, you told me you had a chance to kind of look these over
Hmm.
and, provide some insights on this. So, Musa provides industry practices to help companies understand and, appreciate their options when it comes to mitigating unauthorized data scraping. And
Hmm.
so, for example, helping companies or people inside your companies understand scraping vector risks
Hmm.
and grading data sensitivity and the impact if they were to be scraped. Is
Hmm.
this something as a cybersecurity and privacy expert that you would think is a reasonable practice for a company who's dealing with scraping and other entities, third-party entities scraping their platforms?
Absolutely. And in fact, this is in many ways the analog to a privacy impact assessment or a data protection impact assessment. So if you already, and presumably everyone on the call here already has a data inventory, you may well have done DPIA, essentially taken that data inventory the next step further. And then that document is essentially this scraping vector risks document. So it's interesting that it's the same idea, it's a different context.
And then detection and mitigation is another industry practice that's included
Hmm.
in the document. And
Hmm.
so basic things like monitoring traffic and identifying indicators are those
Hmm.
things that if you were trying to help a company deal with scraping incidents
Hmm.
or unauthorized web scraping that you would
Hmm.
kind of advise them to do, or
Hmm.
what approach would you take?
Well, there has to be a mechanism. Let's say that you can't stop scraping because of just how your business model works, but at least being able to identify when scraping is taking place and taking technical measures to mitigate it and to be able to report on it and say, yeah, we know we can't stop these guys, but we can at least mitigate it and we can go after potentially the biggest offenders for interfering with our systems, et cetera. At least showing that you acknowledge there's a problem and to be able to show what you could do as opposed to just simply ignoring it or pretending it doesn't happen.
So now I would like to just close with some final thoughts from you,
Mhm.
Scott. We've been talking about unauthorized web scraping now for an hour and 45 minutes, and this is
Yes.
perhaps one of our most thorough, comprehensive, helpful webinars that we've had so far on the
Hmm.
topic. And we hope that our audience, and if you're watching this at some point in the future, appreciates the thought and effort Scott has put into this deck and all the information he's provided today. But if you just leave us with a few closing thoughts, Scott, as one of the foremost experts in privacy and cybersecurity in our country, our audience would definitely appreciate that.
Sure. I mean, one of the funny things about generative AI is that it just has this voracious appetite to just have as much data to train on as possible. And really, it should be a quality, not a quantity issue. But there's just this idea that just get as much data as you can because you want to train on it. And I mean, there's been all kinds of mergers and acquisitions recently, specifically for companies just to get access to that data. However, there's a very dynamic set of changes in law and how this is being addressed, and especially in the EU. That's beginning to become the global standards. And so it's so important to be able to look, one, if you are subject to being scraped, and to understand the implications of that and what you can do. And on the other side of the coin, when you're purchasing data, or even if you're the one doing the scraping, to have an idea that what you're doing probably is not going to make the standards for all the integrity that's necessary to actually create a model that's going to stand up to scrutiny, especially when the EU AI Act comes down. One of the interesting things about the AI Act is that it applies mostly to high risk systems. A great way to avoid becoming a high risk system is really limiting the kind of data that could be harmful to people. And so that goes back to not using scraped data, and also if you're the one getting scraped, to potentially prevent that or mitigate that. So and there's plenty of resources. I know Musa has resources on preventing unauthorized web scraping. So do others. And your audience can feel free to ping me if they want, and I'll go and get a list for them.
Yeah, Scott, if people want to continue the
Mm,
conversation with you,
mm.
where can they find you?
They can find me on LinkedIn, and also at my address here at Director CISOs. Director CISOs, we bring directors and CISOs together. So feel free to reach out to me. I'm happy to send you a list of resources, and I'm very grateful to be on the call today.
Well, Scott, thank you so much again. Such an honor to have you on board and talking with our Musa audience here. And again, my name is David Patariu, and this is the Mitigating Unauthorized Scraping Alliance web series. And we hope you found that's valuable today, and look forward to speaking with you again about a new scraping topic in the near future. Thank you so much, and have a great day.